When you hear the word stalking, what pops into your head? Probably something straight out of a movie, right? Someone hiding in the bushes, making scary phone calls. But the reality of what the law considers stalking is, well, it's often a lot quieter, way more complicated, and honestly, a lot more common than you'd think. So let's pull back the curtain on the Hollywood version and see what's really going on.
So let's get right to it. What does stalking actually look like in the real world, in day-to-day life? Forget the movies for a second. What kind of behavior are we talking about here?
Okay, so on one side, you've got the classic movie stereotype, right? Lurking, hiding, maybe one big dramatic threat. But what the law actually sees is often a series of smaller, almost insidious acts, things like constantly emailing someone's boss trying to get them fired, or filing fake police reports against them, or even sticking a GPS tracker on their car. See the difference? The law isn't looking for one big scary moment. It's looking for a pattern. So let's dig deeper, beyond that Hollywood stereotype, because here's something that might actually surprise you. The legal definition of stalking often doesn't require what we think it does. You don't always need a direct threat. The stalker doesn't even have to want to be seen.
This quote from an Arizona court case, State v. Tiggs, really gets to the heart of it. In that case, a man was convicted just for repeatedly peering into a victim's window. Now, his argument was, hey, I never tried to get her attention, but the court basically said, that doesn't matter. The act itself and the fear it causes once the victim finds out about it, that is the crime.
And that idea leads us straight to the absolute foundation of stalking law. It's almost never about just one single thing. Instead, it's all built on this legal concept called course of conduct. It is all about the pattern.
So what does that actually mean in plain English? A course of conduct is just a series of two or more actions that show the person is working towards the same goal. The court is basically connecting the dots. It's not looking at these as separate, random incidents. It's seeing them as part of a single, coordinated campaign of harassment.
And believe me, this can get really sophisticated. Just imagine this for a second. Step 1. Someone makes up abuse claims just to get custody of their child. Step 2. They use that new custody arrangement as a reason to stop paying alimony. And then, step 3, they harass the victim until they finally give up and waive the alimony for good. Now, each of those steps might look like a separate legal battle, but the law can look at the whole picture and see it for what it is, a course of conduct, stalking.
Now, you might be thinking this takes months or years to build up, right? Well, not always. A pattern can be established in just a few hours. In a Pennsylvania case, a defendant just happened to run into the victim 5 different times in a single afternoon. The court said, yep, that's enough. That's a course of conduct. It just goes to show you that the intensity and repetition of the acts can matter just as much as how long it all goes on.
So we've covered the pattern of what the stalker does. But that's only half the story. There's another piece of the puzzle that's just as crucial. The law also focuses very heavily on the impact of those actions on the victim. This is where fear and emotional distress become absolutely central to the whole thing. The legal test for this is called the reasonable person standard. And this is the part that changes everything, it's not just any reasonable person. It's a reasonable person in the victim's circumstances. That means the court takes into account the entire history between the two people. Think about it. A knock on the door might mean nothing to you or me. But if that knock comes from an abusive ex-partner, that can reasonably cause terror. Context is absolutely everything.
And this is where you often hear a classic defense. Take this case from Wyoming, Dean versus State. The defendant had threatened his estranged wife, he'd violated a protection order, and he called her over and over again from jail. His argument in court? He was just trying to save his marriage.
Yeah, the court wasn't buying it. They looked right past his supposed motive and focused on the real-world impact of what he did. A jury could clearly see that his actions were intended to harass, pure and simple. This is so important. What the stalker says they intended often matters a whole lot less than the predictable outcome of their behavior.
And if you need any more proof that this is about creating fear, just listen to this incredible quote from a Connecticut court. The law can be violated without a defendant's uttering a syllable, writing a word, or making a gesture. In that case, the defendant's creepy behavior, just showing up everywhere, staring, was enough. That pattern of just being there, that alone can be terrifying.
Okay, but we're living in the 21st century, and of course, the stalker's playbook has gone digital.
Technology has opened up this whole new, terrifying frontier for harassment, creating all kinds of new ways to invade someone's life.
And you can see how the law is literally racing to keep up. States like Arizona now have specific statutes, which are just laws passed by their legislature, that go after harassing texts and emails. Rhode Island has laws that make it illegal to put a GPS tracker on someone's car without their permission. And places like Delaware are criminalizing doxing and the malicious sharing of private images. The legal system is actively trying to adapt to every new tool in the stalker's digital toolkit.
And here's another thing. Stalkers can't just outsource the harassment. The law in Washington, for example, is very clear about stalking by proxy. That's when you get your friends or anyone else to do the harassing for you. Well, that's still stalking. The person who started it all is the one who's held responsible.
So with all this going on, what can the legal system actually do to stop it? Well, the main tool in the toolbox, the thing designed to stop the behavior before it gets any worse, is the protection order.
A protection order, which you might also hear called a restraining order, is basically a legal stop sign from a judge. It's a civil court order, and it has one crystal clear purpose: prevention. It's designed to draw a line in the sand and stop the harassment right in its tracks.
And to make that really concrete, let's put a number on it. In Florida, for example, a protection order can legally require someone to stay at least 500 feet away from the victim's house, their job, even their school. It literally creates a physical and legal buffer zone.
And these orders are no joke. They can be incredibly broad. They can demand a total shutdown of all contact, no calls, no texts, no emails. They enforce those stay-away distances. And in many states, they can even force the person to surrender any firearms they own. The whole point is to cut off every single avenue the stalker was using to make the victim's life a living hell.
So, you see, the law has these very specific tools, these definitions written in black and white, to try and pin down a type of behavior that is often intentionally vague and subtle. And that leaves us with this big, lingering question. Can these black and white laws ever be enough to truly protect someone who is stuck navigating the deep gray areas of psychological intimidation and fear?